for tonight. I am now going to introduce our lecturer, and I have to say I'm really delighted to welcome Sophia Z. Lee to Marshall University. Dr. Lee is a professor of law and history at the University of Pennsylvania Law School. She's a legal historian who earned both her law degree and a PhD in history from Yale, and she also holds a master's in social work and her undergraduate degrees from the University of California, Berkeley. Before coming to Penn, Dr. Lee served as law clerk to the Honorable Kimball Wood, United States District Judge for the Southern District of New York, Chief Judge actually. And at Penn, she teaches courses that are focused on administrative law, employment law, constitutional theory and history, and civil rights law. She's lectured around the country and at such prestigious venues as Stanford and Yale and Columbia and Harvard. And of course, we're delighted to have her here tonight. She's written extensively, including contributing chapters to books, textbooks, and writing scholarly articles, which can be found in the Yale Law Journal, the University of Virginia Law Review, and the Law and History Review. Most relevant for our purposes tonight, she's written a book called The Workplace Constitution: From the New Deal to the New Right. That book won honorable mention in the 2015 J. Willard Hurst Law and Society Association prize competition. Particularly in light of the issues that we've seen at the forefront here in West Virginia and around the country, I think her topic is really, really timely. And I'm very eager to hear her. I know you are too. So without further ado, please join me in welcoming Sophia Lee.
So I know what you're all really wondering. What on earth does the Z stand for? That's Zoila. It's my grandmother's name, a family name, and one I would be surprised if there's maybe nobody in the room who's ever heard of it before. It was certainly a name when I was a kid. I was like, oh, I'm embarrassed. That's such a weird name, and I've come to love and embrace. So that's the Z, the Sophia Z. Lee. I want to thank you all for coming out tonight. It's really wonderful to see you all here. And I wanted to give a special thanks to Patricia Proctor for that lovely introduction and for inviting me. And as I was just telling her, being a superlative host in my time that I've been here already. And I also want to say it's an honor to have an opportunity to contribute to the work of the Center for Constitutional Democracy, and an honor to be here with you tonight to talk about my book, The Workplace Constitution: From the New Deal to the New Right. So, I thought I would spend my time tonight, start out by providing a brief overview of the book, and then take us on a deeper dive into one of the strands of its interweaving stories, and that is a history of the right to work movement. And I will use this history to highlight a couple of the book's arguments, one about the history of mid to late 20th century conservative legal movements more generally, and another about the ways in which constitutional law has been shaped not only by courts and judges, but also by the organized efforts of ordinary, and as you'll see as I tell this history, at least in one case, very extraordinary persons. So, and then I'll close at the end, just bringing it up into the current day, close with some thoughts about what this history might suggest about the future of labor law and politics. I chose to focus on this part of the book, as Patricia just signaled in her introduction, because I thought the history of right to work and the question of the future of labor rights seemed like a particularly timely part of the book to focus on, just given recent events here in West Virginia. And I look forward, I should say, to your questions at the end, given that. So I have some slides, and let me make sure got that on. Let's see if that worked. Okay, great. So, title of the book, we've got that part down. It's a history, not surprisingly, of what I call the Workplace Constitution, given that that's right in the title. But what do I mean by that? By the Workplace Constitution, I mean the idea that workers would have constitutional rights on the job and in the union. So the place to start is where we are now. Today, most workers lack constitutional rights on the job. Okay, really the only workers who have any kind of constitutional rights are public sector workers. If you are one of the vast majority of workers who works in the private sector, you do not have any constitutional rights. And that means that that vast majority of workers today can be fired for attending a gay rights or a pro-life march on their own time, for example. In fact, with few exceptions, they can be fired for any reason or no reason at all. There are some constitutional protections for public sector workers, but there are weaker versions of those rights than we see outside of the workplace. So the book is in some sense about solving a puzzle. And that puzzle is that I think if I could take you all back in a time machine, back to the 1950s, and look forward at the 21st century, given what was going on all around us back in the 1950s, we might well have predicted that there was a very good chance that come the 21st century, workers would have robust constitutional rights on the job. And that was because there were two powerful movements, one on the left and one on the right in the 1950s, that were both pushing for these rights. So it seemed like something that might be able to bring people together across the political spectrum. And it seemed like, just given the heft of the two movements pushing for them, either one of them had a good chance of success. So on the left, you had the civil rights movement. Otherwise, we know the civil rights movement was very successful at transforming the Constitution during this period. And in the 1950s, the civil rights movement was engaged in coordinated litigation to win for African American workers a constitutional right to access decent jobs, well-paying, skilled jobs, and a right to join unions and benefit from collective bargaining. In many ways, this litigation mirrored what the better-known cases they were bringing to challenge public school segregation during this period. At the same time, on the right, you had the right to work movement, which was well-funded. It had some very high-profile leaders, and it had growing grassroots support. And the right to work movement during the 1950s was also engaged in this kind of coordinated litigation, much like the NAACP's more famous Brown versus Board of Education litigation. Only for the right to work litigants, they were trying to win a constitutional right not to have to join or support unions. So the civil rights movement and the right to work movement both were trying to win constitutional rights in the workplace, but towards very different ends, right? African American workers were trying to win a right to join unions. Right to work litigants were trying to win a constitutional right not to have to join or support unions. So the book recovers how these movements got much further towards their goal than is currently appreciated, but it also explains why it is that they never fully succeeded, in the hopes that history will help workers today assess the costs and the benefits of a workplace constitution. So the book has three main sets of arguments, and I'm just going to go over those really quickly now. The first has to do with the history of civil rights. And here I argue that workplace rights and economic justice were really a much more central and persistent part of the civil rights movement's constitutional agenda than historians have recognized. We know a lot about school segregation, but we don't know this history of trying to win a workplace constitution. And another set of arguments that have to do with constitutional history outside the courts, I argue that non-court actors, from government agencies to ordinary people, have played a really important role and I think an often overlooked role in determining how the Constitution is actually implemented, both in the courts and outside of it. So I think you can't really understand constitutional history if you just look at what the courts have done. And then the third set of arguments have to do with the right to work movement itself and its implications for post-New Deal conservatism. And I argue that looking at the history of the right to work movement really requires us to rethink some of what we think we know about the history of post-New Deal conservatism. So I'm happy to talk about the first one of these arguments, the civil rights part of the story and the question and answer, but I'm going to focus here on on the second two sets of arguments. And just to give you a little more of a sense of what those arguments are before I go into the deep dive, I thought I'd just give you kind of a brief summary of the right to work history, and then we'll expand it out. So in particular, I argue that the right to work movement pioneered many aspects that are actually associated with late 20th century conservatism. So for example, these are the names of a number of late 20th century conservative legal organizations. You may have heard of some of them, the Center for Individual Rights, there's the Mountain States Foundation, the Institute for Justice. So these are thought to have been a sort of a new thing in the late 20th century when conservatives started forming these kinds of public interest law organizations modeled after things like the NAACP's Legal Defense Fund. But the right to work movement actually shows that conservatives were investing in coordinated litigation and constitutional law long before these better known organizations came into being. So all the way back, as I'll tell you in a little bit, all the way back to the 1940s. Another thing that this history shows is that the right to work movement was promoting a populist image by showcasing plaintiffs that were workers, racial minorities, and women, and which is also a strategy previously associated only with these late 20th century conservative legal organizations. And the picture that just popped up is a picture of some right to work plaintiffs in the 1970s on the steps of the Supreme Court. And I will tell you more about those plaintiffs and the case that made them smiling on the steps of the Supreme Court in just a little bit. So through these strategies, right to work advocates were able to dramatically change how courts thought about their constitutional claims. But I also use this history to challenge accounts of conservatism itself, which has often treated the new right, the rise of the new right with President Reagan and beyond, as sort of a seamless juggernaut. They had it all figured out, and they just took the reins of power with incredible strategy and really no failures and no dissent. And instead, I argue that the history of the right to work movement reveals that there were important fissures among conservatives as they rose to power in the 1980s. And these are just some faces of that rise to power, conservatives rising to power in the 1980s. We have, obviously, President Reagan. In the lower, I guess, for you would be your left-hand corner there. That's Ed Meese, who was the Attorney General under Reagan. There he is dancing with Sandra Day O'Connor in one of those pictures, and standing there with Antonin Scalia in another. You can probably figure out which is which between those two. So right to work did not fit well into the constitutional revolution that the Reagan administration was leading. And so it revealed tensions within conservative constitutionalism, particularly between more libertarian, rights-focused wing of the movement and its more judicial restraint-focused wing that really wanted to undo some of the what they saw as the over-enforcement of the Constitution associated with the Warren Court and the Civil Rights Revolution of the 50s and 60s. And I think those tensions are still with us today, which is why I think it's worth revisiting them. In fact, I think they're relevant to the fate of right-to-work constitutional claims that are before the Supreme Court right now. A decision could come any day, and to the future of the workplace constitution more broadly. So that's the overview, and now I'm going to take you on a deep dive into that history of the right-to-work movement. So let's start with the question of where the right-to-work movement came from. So it was really spurred by the New Deal. During the New Deal, there were, for the first time, federal labor laws that gave unions the right to organize and that required employers to recognize and bargain with those unions that could demonstrate sufficient worker support. Okay, so with these labor laws in place, the labor movement did expand rapidly. So it went from about 1 in 10 workers being a member of a union before these labor laws were enacted to, by the 1950s, about 1 in 3 workers being a member of a union. So a pretty dramatic shift in just 15, 20 years. And while unions themselves were expanding rapidly, something called union security agreements also were spreading. And these were agreements that required workers to be a member of or pay fees to a union in order to get or keep a job. A number of different versions of them, but that was the basic concept, that you would have to either already be a member of a union to get a job in the first place, or once you got the job, you would have to either join or at least pay some dues or fees to the union to keep your job. So as you can imagine, these agreements helped increase union membership, because now if a union won representation in a particular bargaining unit, anyone who worked in that unit was going to have to join or at least support the union. And these agreements, these union security agreements, along with the unions that were seeking them, were opposed by anti-union conservatives and also employers who instead advocated what was called an open shop. This would be a shop in which, a workplace in which there was no obligation to bargain with the union and no obligation to join or support the union. So by the end of the 1930s, these open shop proponents were looking for a way to counter this growing Union and Democratic Party power, because the unions, in at least these open shop advocates' view, were closely allied with the Democratic Party. Now, historians have talked about how these activists turned to state right-to-work laws, and these are state right-to-work laws, much like the one that was recently passed here in West Virginia. These were laws that stated that no worker would have to join or support a union as a condition of their job. But my book is the first one to examine how litigation factored into their efforts. So how their efforts to bring constitutional arguments in courts also fed into this push for the right to work. And so that's the history that I'm going to focus on here today. Now, one of the very first, and as far as I think maybe the first right-to-work cases that was brought by a Hollywood mogul, sort of maybe not who you would expect to be the face of a right-to-work case, Hollywood mogul Cecil B. DeMille in the 1940s. I imagine there are some of you in this room who recognize this man very well, others of you who have never heard of him before, but he was sort of like the Steven Spielberg, maybe, of the 1930s and 40s. He was a movie producer, director, he made blockbuster films. He had started really with the motion picture industry and sort of helped build the modern motion picture industry. So very well-known man. People were familiar with his movies. He also was the host of a very popular radio show, the Lux Radio Hour, that did, I see someone saying, I remember that, right? So I think they did snippets from Broadway musicals and things like that on the show. So it was that itself was also a popular show. But the station he broadcast out of was a closed shop. So the radio, you had to be a member of the Radio Artists Union in order to broadcast there. So Mr. DeMille, even though he was a movie mogul, also had to be a member of the Radio Artists Union in order to broadcast his radio show. Now, California in the early 1940s was going through its own push for a state right-to-work law. This was Proposition 12. It was going to be on the ballot because there, rather than the legislature enacting a law like this, the voters had an opportunity to vote for whether they wanted to adopt a right-to-work law. So DeMille was a supporter of this right-to-work law that was going to be put to California voters. He was generally sort of a conservative who had been very active in Republican Party circles and was definitely more of an open shop kind of guy himself. So he wanted to see this law passed, but his union was opposed to it, not surprisingly. So to help fight the law, the union imposed a $1 fee on all of its members. Well, as you can imagine, DeMille was not happy about this, and he argued that it was actually unconstitutional for his union to charge him that $1 to help oppose a right-to-work law that he wanted to see passed. So this is, here you can just see this is a brochure that was made about his lawsuit, where he talks about the sort of principles of liberty and freedom dating back to the founders that are at stake in this case that he brought in the California courts. Now, the courts, unfortunately for Mr. DeMille, easily dismissed his case. They just didn't see anything wrong with DeMille's union requiring him to support its campaign against the right to work law. They reasoned that no one saw the union's position as Mr. DeMille's, and that Mr. DeMille remained perfectly free to spend his considerable fortune supporting the law if he chose to. So there wasn't really any way in which either his right to vote or other kinds of rights could be violated here. So DeMille wanted to change how the Constitution would apply to this issue, to these kinds of claims. But he decided that the best way to do this was primarily through political education and popular mobilization, and only later through litigation. He thought you really had to change the context in which the courts were deciding cases before they were ever going to come to see any merit in these constitutional claims. So he founded the DeMille Foundation for Political Freedom. This was a foundation that was funded and run by a group of industrialists and conservative activists. But DeMille and his fellow foundation runners really wanted to get a more popular buy-in for the right to work cause. So they really wanted to win the support of this broad public that Mr. DeMille already had as this famous radio host and filmmaker. And DeMille himself, as we know, was a pretty good showman. He knew what sold, and so he put his sales talents and showmanship talents into trying to win people over to his constitutional argument. So he made this constitutional argument for the right to work through national radio broadcasts, in lots and lots of speeches all around the country. He even made a short movie telling the story of his $1 forced donation. He testified before Congress. And meanwhile, his foundation itself cultivated favorable editorials in newspapers across the country, and supported and helped with strategy for state-level right-to-work committees that would be promoting the right-to-work cause in a state-by-state campaign. So all of this was part of the foundation's efforts to use public education to change how people thought about constitutional law. And DeMille then thought by the 1950s it was time to reintroduce litigation into this mix, but this time he was going to do it in a very different way. And you could see the effect of these efforts in the 1950s when union security agreements came to the railroads for the first time. Now, these agreements met strong opposition from railroad operators and a number of railroad workers. And so the railroad companies and their workers joined forces with each other, along with the support of the DeMille Foundation, and what was then a new actor on the scene, but one that's still around today, and some of you may have heard of or know of, is the National Right to Work Committee. So it was really formed in some ways out of this moment and these railroad cases. And they all got together to challenge the constitutionality of these union security agreements. Now, this litigation was very different than DeMille's an original case in several ways, in ways that I think reflected the efforts that he and others were making to change the way the public and the courts thought of right-to-work constitutional claims. So one difference is this slide up here shows you a brief in one of these railroad cases that was filed with the Supreme Court of the United States, where a number of these cases ultimately ended up. As you can see, there are lots of names listed of who these workers are who had signed on to the brief. So one thing that was different about these cases is there was no longer just a solo litigant. Now there would be many plaintiffs and many cases. So DeMille's coalition brought over a dozen suits around the country challenging the constitutionality of union security agreements on the railroads. Each of these cases had dozens of plaintiffs. And in many ways, this litigation looks a lot like what the NAACP was doing at the same time in challenging school segregation, in terms of this coordinated effort to do it in many parts of the country, many litigants at once. Okay, another difference was that workers were now out front, and big money opponents like DeMille were in the background. And you can see that if you just compare Cecil B. DeMille, right, our first right-to-work litigant, compare him with who we get in the 1950s and on. So one of these plaintiffs is Lafayette Hoosier. Hoosier was a former member of the Brotherhood of Locomotive Engineers who became a right-to-work activist. He became a leader in the National Right-to-Work Committee, and he was the first worker named in that brief that I just showed you on the last slide. Okay, so now people like Lafayette Hoosier, by the 50s, this is the face of the right-to-work movement. These are who the workers are who are being, whose rights are being violated. No longer people like Cecil B. DeMille. If you go to the 1960s, similarly, a shift to include not just workers, but more African Americans and women. So you have here Ernest Smith. He was a teacher in Detroit who helped organize about 5% of Detroit's teachers to join a right-to-work lawsuit in the late 1960s. And here you can see, here they are after they were victorious. These are the same teachers I showed you a few slides ago on the steps of the Supreme Court in the 1970s when they had a very big win in the court. So this putting workers in the front was not an accident. It was really part of a concerted effort to give the movement a worker face. And in fact, DeMille's Foundation generally counseled right-to-work organizations and activists to keep the moneyed supporters in the background. And this quote comes from a memo or correspondence between someone who worked in DeMille's Foundation and one of the state right-to-work groups, basically saying, yes, the big money people are going to be the one calling the shots, but they should not be in the face of the movement. They should be in the background, call the shots from the background, but have the face of the movement be ordinary people, housewives, farmers, workers. That's who people should associate with the right-to-work cause. Another way that these cases evolved is that they shifted to mimic civil rights and civil liberties litigation of the times, not only in featuring African Americans and women and minorities as plaintiffs, but also in other ways in terms of the rhetoric and the claims that they made. So when DeMille first started out, he made old-fashioned kinds of constitutional claims that were really associated with business interests who had opposed unions and opposed government regulation during the Progressive Era and the New Deal. He also talked about the right to work as protecting the majority of Americans against a small group of corrupt and communistic labor bosses. By the 1950s, right-to-work activists had shifted this rhetoric and shifted the nature of their constitutional claims. So one way they shifted their rhetoric is even by 1947, DeMille stopped talking about the workers whose rights he was fighting for as being in the majority and started talking about these rights as protecting a minority, right? This was more in keeping. This is the period in which the court really starts being solicitous of minority rights, concerned about people who might be oppressed in our system because they are minorities and not able very well to assert themselves in terms of electoral politics. So DeMille gets with the times. He starts talking about right to work as a minority right rather than a majority right. And instead of these old-fashioned business rights claims that had really been rejected by the Supreme Court during the New Deal, right-to-work advocates emphasized what were newly popular with the Supreme Court, claims like First Amendment rights. Right? This is a time this court has just started to recognize First Amendment claims in the late 30s and 40s. And so DeMille and his allies get with the times. They're framing these now as minority rights that really are part of this larger civil rights and civil liberties revolution that is starting to get way in the Supreme Court. So the particular kind of arguments they're making, like I said, they're First Amendment claims. They're basically arguing that union security agreements violated their freedom not to speak, rather than we think of free speech. Well, this was kind of the opposite, the freedom not to speak. And we know about the freedom to associate. They were saying, well, we also have a freedom not to associate, right? This is the nature of the First Amendment claims they were making. Now, These were also claims, I should say, that DeMille, again, had already added to his lawsuit as it moved up through the courts of appeals in California. But now, by the 1950s, when we get to the railroad cases, they really form the core of the right to work constitutional case. And frankly, he had the lawyer he had in his California case is not a constitutional lawyer. And by the time they get to the railroad cases, they've really got some big legal minds working on how to strengthen these kinds of new minority rights First Amendment claims. Another thing that was different, I'm getting a little ahead of myself there, was that their goal was more sweeping. So remember, DeMille had just challenged the constitutionality of having to contribute to unions' political speech, right? He didn't want to have to help them oppose this law that he wanted to see passed. But in the railroad cases, right-to-work lawyers got more ambitious and made claims that were closer to what they really ultimately wanted to see, which was to argue that the union shop itself, that these union security agreements themselves were unconstitutional because having to pay any dues or fees violated the First Amendment rights, right? So the idea, these were more ambitious and sweeping claims that would make union security agreements in their entirety unconstitutional. Now, DeMille's strategy was effective. Over time, courts changed how they thought about the movement's claims. So if you remember, I said when we started with DeMille, the courts basically easily dismissed his forced speech claims, and this is just a quote up here from the California Supreme Court's decision in his case. By a decade later, the Supreme Court had signaled sympathy with DeMille's claims. So in just 10 years, a pretty big change in how the courts were seeing these claims. So first, in the 1956 railroad case Hansen, which I have a quote from here, the court showed sympathy for the claim that fees for unions' political speech were unconstitutional. It didn't end up deciding the issue there, but it said this sounds this really does sound like a constitutional problem. Then in 1961, in another one of the railroad cases, those constitutional concerns led the court to find that the labor law that governed railroads gave objecting workers the right to opt out of supporting unions' political speech. So they avoided the constitutional question, but ultimately gave the right to work litigants the right to at least opt out of unions' political speech. And then finally, in the 1970s, the Supreme Court adopted DeMille's constitutional theory full on. In this case, Abood versus Detroit Board of Education. This was the case that Ernest Smith helped organize back in the 60s, and that those beaming worker plaintiffs on the steps of the Supreme Court were celebrating. And in Abood, the court held that public sector workers indeed had a constitutional right to opt out of supporting unions' political activities. Okay, that it did create a constitutional problem for them to be forced to support unions' political activities. So this was a pretty big shift, right? This is about 30 years, pretty big shift in the law. This is just a little bit more from Abood and another glimpse at these happy plaintiffs. This was a huge victory for the right to work movement, which had used coordinated litigation and this political mobilization to change constitutional law. But it also, at the same time that this Abood was a victory, it also demonstrated fissures among conservatives that would only grow in the following years. So sort of a moment both of culmination and victory, and also some signs of future problems for the right to work cause. So one thing to realize is that the idea that public sector workers would have First Amendment rights on the job was very new when Abood came to the Supreme Court. It was really only in 1968 that the Supreme Court clearly recognized government workers as having any kind of constitutional rights, First Amendment rights on the job. And generally, it was the liberal justices on the courts who pushed for these robust First Amendment rights for public sector workers like Mr. Smith and the other Detroit teachers. The conservative justices on the court, in contrast, generally opposed those rights. But in Abood, the conservative justices were divided, and all of the justices' positions on these First Amendment rights were scrambled a bit by the right to work claims. So to reach the majority position, Liberal justices who had been pushing for these robust First Amendment rights for public sector workers instead reverted back to an older, weaker version of First Amendment rights. And relying on this older, weaker version of First Amendment rights, they found that union security agreements were constitutional as long as objecting workers had a right to opt out of unions' political speech. So while this was a win on the one hand, because it finally recognized what DeMille had said 30 years earlier, it was also a loss because the court stopped shy of that broader claim that the right to work advocates had started making in the 1950s of saying any kind of union security agreement should be unconstitutional, not just the requirement of supporting political speech. Okay, so that was the liberal justices backed away from these robust First Amendment rights. Meanwhile, most of the conservative justices, and here they come, the conservative Nixon appointees who generally had resisted these robust First Amendment rights for public sector workers, argued that the majority didn't go far enough in protecting the dissenting workers' First Amendment rights. They insisted that the court should have applied the most robust approach to First Amendment rights that it had recognized all the way back in 1968. And based on this approach, they argued that all required support of unions might be unconstitutional, not just this narrow question of support for unions' political activities. So there's one, if you add everyone up here, right, we're missing someone. There's one justice missing here, and that would be Justice Rehnquist. Okay? Justice Rehnquist was one of President Nixon's most conservative appointees. He went on to become Chief Justice of the Supreme Court. He parted ways with the other conservative justices on Abood. He hadn't agreed with the liberal justices when they pushed for those more robust First Amendment rights for public sector workers in the first place. And he wasn't going to push for those robust rights now, even though they would benefit, in this case, a conservative cause. So instead, Rehnquist sided with the liberal majority, not his fellow Nixon appointees, and found most union fees constitutional. Okay? Now you see similar fissures among conservatives when the next big right-to-work case came to the Supreme Court in the 1980s. This is, up here you can see that Harry Beck is the lead plaintiff. In this suit, he was a telephone worker, and this was a suit brought against the Communication Workers Union. And this was going to be a new front in the right-to-work fight. So remember in Abood, that Detroit teacher case, that had just recognized the constitutional rights of public sector workers, teachers like Mr. Smith. It didn't say anything about that vast majority of private sector workers I was talking about in the very beginning of my remarks. People working at telephone companies like Mr. Beck, or maybe working in mining operations, which would be more familiar and present here. So Mr. Beck's case really sought to expand the constitutional right not to join or support a union to these private sector workers, beyond the teachers to this vast majority of private sector workers. Now, there were many reasons to think this was a good movement for the right to work cause. President Reagan is elected. He is himself a former right to work spokesperson, so seems like they have a really good ally in the White House. He appoints people who are allies with the right to work movement to important positions. So right-to-work advocates thought that this next run at the Supreme Court would be victorious, that they would be able to extend the constitutional rights they'd won in Abood to this vast majority of private sector workers. But they had a legal problem. And that legal problem is that the Constitution traditionally applies only to the public sector and not to the private sector. Okay, that is a long-standing rule, and while civil rights lawyers had tried to make it budge for decades, and right-to-work litigants had been working on it for a while, that was still the standing rule. Constitution only applies to the public sector. Now, the right-to-work litigants had gotten around this in the railroad cases when the court said that the railroad labor law itself gave workers a right to opt out of political dues. And this rule wasn't a problem in Abood because we had public sector workers, and so there wasn't a question about whether the Constitution applied. But for them to argue that the Constitution reached these private sector workers, right-to-work litigators had to rely on what were basically super liberal arguments about the breadth of the Constitution's reach. I mean, these were arguments that some in the civil rights movements would make, but not even all. They were arguments that only the court's most liberal justices were willing to contemplate. So super liberal arguments that the right-to-work movement was going to have to make in this case. That happened to be pretty out of step with where conservatives were going in terms of thinking about the Constitution in the 1980s. Okay, so in the 1980s, conservatives were really looking for ways to undo the liberal rights revolution of the 1950s and the 1960s. That was their primary goal, and to honestly to protect the presidency itself also from the courts. They did not see the courts as a great ally, and they really coalesced around what's called originalism, which was an approach to interpreting the Constitution, and it basically originalism held that the Constitution should be strictly interpreted to mean only what it had meant at the time that it was ratified. So if you can imagine, if that's the governing theory of the Constitution, these right-to-work advocates' broad, super liberal theories of the Constitution's reach were a little out of step with where the rest of the conservative legal movement was going. So instead of securing this great constitutional victory that they were hoping before the Supreme Court in the 1980s, instead the right-to-work movement divided the conservative coalition. It led to a huge battle within the White House and the Department of Justice over what the government's position should be before the Supreme Court, because the government was going to file a brief, and what was that brief going to say? Was it going to support the right-to-work litigants or come out against them? And like I said, there was a huge fight. There was sort of a race to the courthouse, and ultimately the brief filed by the Solicitor General, who's sort of the head lawyer of the United States, he went to the Supreme Court and argued that there was no basis in the Constitution or the statutes for the right-to-work litigants' cause, which led to kind of surprising headlines like these, right? So what do the newspapers all say? Reagan is basically coming out in favor of the unions, okay? So it wasn't just the Solicitor General who thought that the right-to-work movement's arguments were just too out of step with where conservatives were going with the Constitution and the law. Indeed, 3 of the court's conservative justices agreed with him, and they included Reagan's appointees, Justices Antonin Scalia and Justice O'Connor, Sandra Day O'Connor. So their position reveals tensions between those in the conservative legal movement who believed it was true conservatism for the courts to enforce constitutional rights, those people like the right-to-work movement, right? And those who believed courts should limit their use. And I would just say the right-to-work movement wasn't alone. They had a lot of supporters in the DOJ and the White House that were trying to outmaneuver the Solicitor General on this one. So a real division here among conservatives. Should courts be, should conservative justices be protecting rights, or should they be limiting their use? In the 1980s, when this is all happening, the conservative justices who believed in judicial restraint were still in the minority on the court. The majority in Beck's case actually sidestepped the constitutional issue and did something like the court had done back in the railroad cases, which was to find the labor law itself to give objecting workers a right to opt out of some fees. So right-to-work advocates kind of had another mixed, kind of a half of a win, half of a not getting everything they wanted. So they got the principle of not having to support political speech, but they didn't get it on constitutional grounds, and they didn't get that larger goal of having all union dues and fees, having to pay any union dues or fees declared unconstitutional. But in terms of victory, right, they had moved the courts quite a ways in the years in which they had been they had been pressing this cause. And so while they didn't win everything they want, I do think that the series of cases, from the railroad cases to Abood to Beck, does demonstrate how popular mobilization outside the courts can change the law that we see inside the courts. But as I said earlier, I think this history also shows some of the fissures within the New Right coalition, because conservatives, it turned out, were divided over the wisdom of pursuing a rights-based or a judicial restraint-focused strategy. And these are tensions that right-to-work claims, I think, particularly highlight, because they create strong pressure on conservative justices to recognize rights claims that they might normally reject, right? So if there's ever going to be a rights claim that you would think someone like Justice Rehnquist would want to endorse, it might be this right-to-work claim, right? So these are tough cases for the conservative justices. So that's the deep dive into the history itself. I did say I'd close with some remarks on the future of labor law and politics. So I'm going to give us a quick zip from this point in time, the 80s, up to the present day, and talk a little bit about what's happening with all of these issues right now and what maybe is likely to happen in the future. So after the 1980s, the law and policy of right to work entered a period of, I would say, prolonged stability. There were a peak of 25 states with right to work laws in 1955. By 1980, they had settled down to around 20, and they remained there for decades after that. And while there continued to be a lot of right-to-work litigation after Beck, it really just nibbled at the edges of the settlement reached in the cases that I just discussed. This idea that workers did have a right to opt out of things that the union were doing above and beyond collective bargaining, governing under the contract, grieving cases, things like that. But that the core idea of union security agreements that all workers should have to support at least some of what some of the union's work remained in place. Right? That settlement held. Then we get to 2010, and I think since 2010, that settlement has broken down steadily. So now we have 28 states with right-to-work laws, and these include states that had been union strongholds like Wisconsin and Michigan. It includes West Virginia, too, as you're all well aware. You also have a Supreme Court that is poised to overturn Abood and to give right-to-work advocates what they had been after now for over 60 years, since they brought those railroad cases back in the 1950s, which is to declare it unconstitutional for at least public sector unions to require any kind of fee at all. And this is a case pending right before the Supreme Court now. They've had oral arguments. We're all just waiting for a decision by the Supreme Court. The case is Janus versus the American Federation of State, County, and Municipal Employees. This is a picture of Mr. Janus himself up here. And the Janus case, now that you've heard this history of the right-to-work movement, has all the hallmarks of that movement's strategy. So first of all, we have an ordinary worker who is the face of this movement. He claims that this is all about freedom and pursuing sort of fundamental American principles. That's what's animating this litigation. And his lawyers are arguing that everything that a public sector union does is political. That is the exact same argument that Abood's lawyers made to the Supreme Court in the 1970s, and the majority of the court rejected, right? So this is the same argument as Abood, coming back to the court again and hoping for a different outcome in the way the court decides it. Now, I think the history that I just shared gives some perspective on Janus itself, what's likely to happen, and also on the fate of workers' constitutional rights. So I thought I would talk a little bit about that. First, I would say the history suggests the slimmest of chances that Mr. Janus could possibly lose before the Supreme Court. I say slimmest with emphasis. I don't think it's very likely, but if there is any way that he is not going to win, I think the history that I've just told is the guide to why that might be the case. But even if he does win, I think that also will tell us something about how today's legal conservatism is different from that of the late 20th century. So, how might he lose? Well, just like in Abood and in the private sector worker decision in the 1980s, it's possible that Janus could split the court's more rights-focused conservative justices from those who are more inclined to limit the Constitution's use. I think that was more likely under the old court, which is who you have pictured up here. You may notice there's someone up there who is no longer with us, and that would be Justice Scalia. I think it's less likely to happen under the new court. Our newest justice, Justice Gorsuch, we don't know exactly where he falls, but I think of him as more of a rights guy than a restraint guy, and so I think he is not likely to be the one who would vote against Mr. Janus. If anyone would, I think it would have to be Justice Kennedy, who is the one down here on the right, and I think he is the closest thing to a wild card on the court. Now, Kennedy is well known for his pro-rights positions on issues such as marriage equality, but like Rehnquist before him, he has not been a big fan of public sector employees' First Amendment rights. So in 2006, he wrote an opinion for a bare majority of the justices that made it harder for workers to succeed on these claims. So I think if there is a Rehnquist on this court, it has to be him. So maybe, just maybe, like Rehnquist, he will stick with this position and fight against Mr. Janus. I think more likely that is not going to happen. I think more likely all 5 of these justices will agree with Mr. Janus that it is unconstitutional for public sector workers to have to support a union in any way. But I think the fact that in recent years, Justice Kennedy and really even Justice Scalia before he died shifted more towards rights, or at least away from some of the principles of restraint that they had stuck to in their prior years on the court, really underscores how this rights-friendly approach has moved from the margins to the center of conservative legal thought. So the right-to-work movement for a long time was a little bit out in the wilderness of conservative legal thought, and I think their focus on constitutional rights as an important part of the conservative constitutional movement has gotten much more sort of to the center of where conservative legal thought is today. I think they've really moved from the margins to the center. And I think if Mr. Janus wins, these rights-friendly conservative justices are going to face more hard choices between principle and politics, because a win for Mr. Janus would open the door for expanding the First Amendment the First Amendment rights of all public sector workers. These include things like the constitutional freedom of association. Freedom of association any of you who've read the Constitution or even just the First Amendment lately know it doesn't say anything about a freedom of association. Freedom of association actually was a concept that started in the labor movement, and it was a claim made to support the right to organize, and it didn't make its way into our constitutional jurisprudence until the late 1950s. So at its heart, it has been, it was first and foremost a right that was used to defend the workers' ability to organize and act collectively. That's the same right that's being asserted by Mr. Janus. And so a win for him could be a win for other public sector workers who want to use this right to protect their collective efforts. For instance, in states that lack a public sector labor law, perhaps. I think Janus also could expand public sector workers' free speech rights, which, along with their rights of association, could be fashioned into a more robust right to strike, to push back on some of the restrictions on public sector workers' right to strike. And another thing that a Janus win will likely do is have the court say that even collective bargaining over terms and conditions of work are protected political speech. That basically anything you talk about that has to do with the workplace in a public sector workplace where budgets are going to have to be passed is inherently political speech. And if so, I think a win in Janus then could strengthen free speech protections for public sector workers' efforts to improve those same terms and conditions of work. Once those are matters of protected political speech, they may be more robustly protected for all workers. So interestingly, for decades, the right to work, the fact that right to work claims were out there, that the right to work movement was making these constitutional claims in the public arena and in the courts, that has really caused labor to deny the constitutional significance of this kind of speech and argue generally for minimal constitutional rights at work. So the labor movement went from being a movement that embraced constitutional claims, often ones that had not been recognized in the courts, but that really provided a kind of public and political democratic rhetoric for labor rights, right? To a movement by the mid-20th century and until now that has really tried to argue that constitutional rights have nothing to do with what happens with unions, with workers, and with employers. They may lose that right to work battle, but once that battle is lost, labor would be free to reclaim free speech and freedom of association as sources of legitimacy, political legitimacy for itself, and also as sources of legal protection. Outside of organized labor, all public sector workers might benefit from these more robust constitutional rights at work. Now, I don't want to be too Pollyannish about this massive change that could occur. I think robust First Amendment rights for all public sector workers are not likely to happen overnight, just like the history of right to work efforts. They did not win their constitutional rights overnight. But I think it opens the door for a longer term strategy that could follow some of the trajectory of what right to work advocates have done over the last 60 years. Because I think this history reminds us that there can be a very powerful synergy between rights claims in the court and popular mobilizations outside of it. And I think if Mr. Janus wins, labor is going to face a choice about whether to embrace a rights-based strategy, both to expand protections for public sector workers and also to try to energize a broader support for labor. And if it does choose to pursue this path, then the conservative justices who sided with Mr. Janus are going to have to decide whether they are going to stick with their principle that speech about the terms and conditions of work is actually due these most robust First Amendment protections, even when that protection is being claimed by workers organizing together or challenging their employer instead of challenging their union. So the book tells the history of how the workplace constitution went from being a bipartisan claim back in the 1950s to one that was really most successfully made and almost exclusively pursued by conservatives by the end of the 20th century. I think ironically, the success of that movement, the conservative success with the workplace constitution, may just usher in a new period in which workers and unions are going to taste the fruit of union opponents' decades-long constitutional fight. They may be able to harness the winds that the right to work movement has won and swing rights back in the other direction, because that is the way constitutional rights work. They are always being reappropriated and redeployed, and that is part of what honestly keeps our constitutional democracy vibrant. So I'm going to end there. I welcome any questions that you have. Yes, please. So the question is, all this litigation is very expensive. We know there's been reporting and books that have come out recently that talk about how deregulatory movements by conservatives today are being bankrolled by people like the Koch brothers or the Mercer family. And so the question was, how did all of this litigation I talked about get funded? That is a hard question to answer because around the 1970s, a couple labor unions sued the National Right to Work Committee. There's in the federal labor laws, there's a provision that limits the activity of employer-dominated groups, right? You can't, so basically trying to bar company unions and protect against company unions. So the labor unions used that provision to say, we need to see the books of the National Right to Work Committee and their Legal Defense Foundation that are bringing all these lawsuits, because we want to see who is supporting them so we know whether they're really not just a public interest social welfare group fighting for the rights of workers, but actually an employer-dominated organization, right, under the federal labor laws. And so ever since then, the donor list for the National Right to Work Committee has been a very closely held secret, and it is very hard to get information. I can say, going back to DeMille and the people who were part of the original funders for his organization, they included industrialists like the president of Alice Chalmers was one of the people who gave seed money to the foundation and was part of its board of directors. Some of them were more small business people. Some of them were conservative strategists, and so DeMille's particular approach was to do fundraising with deep-pocketed people. He actually did not require any membership fees from the ordinary people he tried to also get to join in his foundation on the principle that would, if he was arguing against unions charging fees, he couldn't be charging fees himself. So he did not charge fees. The Right to Work Committee itself doesn't charge fees, but does solicit donations, and I've heard interviews with Reed Larson, who was the head of the National Right to Work Committee for decades. He started around 1960 and basically stayed very involved until his death a few years ago. And he claimed that they got a good amount of their donations from these small donors, that the average donation size was modest, and really this is an oral history from the 1970s, said that there weren't, that this idea that there were these, big deep pockets that were bankrolling the organization was not accurate. I can't see in their books to know if, how accurate that is. So the first question is, why were they bringing constitutional claims at all if they could win under the labor laws when these constitutional claims came along with these fissures and sort of political problems within the conservative coalition? So the answer to that is that there is no way, just looking at these labor laws on their face, you would ever be able to find that they gave dissenting workers the right to opt out. The way the court was able to reach those completely sort of implausible interpretations of the statute was through something that's called the constitutional avoidance canon, which is one of the ways courts approach interpreting statutes, which is to say, if a particular interpretation of a statute would raise a very important constitutional problem, rather than go with that interpretation of the statute that has all these constitutional problems, we'll avoid those constitutional problems and interpret the statute in a way that avoids them. So that was what they did in the railroad cases. They said, big constitutional problems here, definitely, but we're going to avoid them by just saying the statute itself gives workers this right to opt out. Now, it was very clear in the legislative history, this was not what was intended. Like these claims were already out there when the railroad labor laws were amended to allow union security agreements. So everyone knew this issue was out there, and Congress did not give this opt-out right. So it was really you still needed the threat of the constitutional issue to get at the statutory claims that they might ultimately be more likely to win on. That said, I think for DeMille himself, he felt like this was in tension with fundamental American principles and constitutional law. So I think he really felt like there was something special about the Constitution, and anything statutory was a bit of a second best. And I think that has been true for the Right to Work Committee itself. And it's paid off. I mean, they have persisted, in insisting that there is a constitutional problem here over decades of losing that, and now they're going to win it. Which brings me to your second question, which is, how on earth am I being so hopeful, and is there anything we've learned about the future of labor after a Janus loss, and is there anything about the aftermath of recent states that have shifted to right to work after long decades of not being right to work that would suggest there's cause for that hope? I could say I'm just an optimistic person. I try to find the silver lining where I can. But I do think it's interesting. So I've been going around, this book came out in 2014, and when it came out, there were these laws, the states were just starting to shift. There were cases going up to the Supreme Court, kind of trying to broaden the constitutional arguments, but we were not on the precipice we are now. And I started going around and talking about this history with some labor groups because I was curious what they thought about what a world with a national right to work would really look like, and whether, because I have to tell you, from doing this history, one thing I have thought is that, fighting the right to work, this litigation is really expensive. It's expensive as a matter of hiring the lawyers to do it. It's also politically costly. I think the right to work movement has been very effective in packaging their claims in a way, and I think it has been it has been somewhat politically costly for the labor movement to seem to be arguing against these bedrock American constitutional rights. I think it has put the labor movement in a strange position of arguing against workers' constitutional rights. So there are ways that fight has been costly for labor, and so part of what I've been trying to delicately explore is, what if in this moment where it isn't foregone, what if there was some kind of grand bargain? What would you want in exchange for accepting right to work? Is there anything that would be worth it? And it was interesting to hear from people. First, interesting to hear from people in right-to-work states, people who worked as organizers and labor educators in right-to-work states. One thing they said is, we really have to organize our members constantly. And that is a hard thing to do. That is expensive also in terms of blood, sweat, and tears as well as money. But there are also ways that creates a more vibrant labor movement. And so, I think that part of what's happened, and so I was on a panel once with a teacher from Wisconsin after Scott Walker's law had gone through, and one of the things she said is, it's hard, we're losing members, but we also have had to go back and really devote a lot of resources to reorganizing our members. And so, I think there are some. This is, you can imagine that this is a subject of great dispute among folks within the labor movement. There are many people that the fact that I just said these things would be disqualifying. But there are also people who are saying, what we've been doing for decades now isn't working. I mean, we are now back down to the union membership rate being about what it was before the labor laws were enacted in the first place. And so maybe it's time for something else. And I think it's not completely coincidental that you're seeing all this strike activity happening now in states that are right-to-work states. Where you don't have a system of collective bargaining, you're more likely to see strikes. So, I think everyone would agree the labor movement could use some shaking up and new direction. Whether this is the right one, I don't know. But I think it at least offers, if the loss is going to happen, it at least offers something to sort of some ember to pull out of the ashes of the fight. Okay, that's a great question. So one advantage of using legislation rather than constitutional litigation in the courts is you can be a little more surgical, right? So you can pass a statute that gives rights to workers in certain kinds of workplaces, or only some constitutional rights, but not all constitutional rights, say, in the private sector. So there are some advantages to using statutes rather than going to the Supreme Court to trying to win constitutional rights. I would say, the civil rights movement really tried to push to expand constitutional rights to the private sector workplace. The right to work movement really tried to do that. I do not see the court in any foreseeable future being willing to knock down this hard and set line that says the Constitution applies in the public sector, but not in the private sector. So I do not think we live in a world in which at any time soon the Supreme Court is going to say whatever constitutional rights we have them whether we're in the public sector workplace or the private sector workplace. But what we have done in the past, right, this was a problem, for anti-discrimination laws, right? You could bring a constitutional claim against racial discrimination in a public sector workplace, but you didn't have any legal basis for bringing an anti-discrimination claim in the private sector workplace. So we created statutes. We created the Civil Rights Act of 1964 and its Title VII that gives a legal cause of action against discrimination on the basis of race, the basis of sex, the basis of religion, national origin, all in the private sector workplace. So I think statutes are a more likely way to go than constitutional rights, at least for the private sector workplace. So in terms of actual legal protections, I think some of the things that might protect workers might be, for one, more robust protection for their speech and association in the workplace. I mean, I think that actually, like I said, most people are at-will workers. They can be fired for any reason or no reason at all, and that creates a lot of vulnerability. And so I think just giving workers some basic First Amendment free speech, freedom of association rights in the workplace, whether that is through constitutional litigation for public sector workers or through statutes, could go a long way. I think some people really hope that we would go in the direction that most other Western European countries went, which is to provide some just cause termination protections for workers. We have one state that did that, the state of Montana. They did that in the 1980s, but so far they're the only state out there that gives just cause protection, right? So there are ways. One approach would be to try to take some of the things that unions have fought for in collective bargaining agreements for decades now and enshrine those in the law. That's kind of the approach of the folks in the labor movement who are pushing for things like the Fight for 15, right? It's to say that really where we need to go is fighting for laws that give workers rights rather than just workplace by workplace contracts that give workers rights. I haven't spoken with Mr. Janus himself. I can say what his lawyers are asking for in the case is to have the court basically do what the right to work advocates have been asking for since the 1950s, which is to say that it is unconstitutional for any worker to have to support a union if they don't want to, right? Anything, for any purpose, even if that union, under the labor laws, has to represent that worker, has to provide grievance mechanisms, so if they feel like one of their rights under the contract has been violated, they can proceed and seek to have that rectified. The position of Mr. Janus's lawyers is that basically these workers didn't ask for any of that representation and they shouldn't have to pay for it. Where the law already is says that they do not have to join a union. So really this is a fight over, the courts have already said you don't have to join the union, but they have said you have to support that basic representational work that the union is legally required by the federal labor laws to do on your behalf, to negotiate contracts, to administer those contracts, to grieve any problems that come up under those contracts. Those things you do have to pay for because the union has no choice but to provide them for you. The law requires it, right? So that's where the law stands now. And that's really what Mr. Janus and his lawyers are trying to change, is to say, even if the law requires the unions to do those things, the worker isn't asking for them and they should not have to support them. I focused on Janus, but this is actually the most recent of a string of cases. So there's actually been a lot of right to work activity before the Supreme Court just in the recent years. And part of the reason I think Janus is here now is because that stability that I talked about existing from the 1980s on had already started to break down. And so there were cases that came up. I think I actually have a slide. I brought a couple extra slides. So these were two decisions that preceded Janus. The first one was Knox versus Service Employees International Union in 2012. And this was, again, the court here found a way to make a very narrow decision. It just said in this, remember I said workers can opt out of the political speech? They said in this very particular case, instead of opting out, workers get to choose whether they want to opt in. It's not, I mean, it does matter because we're all lazy. And if we have to opt out, we're probably not going to do it. And if we have to opt in, we're probably not going to do it. So it isn't totally inconsequential to switch from opt out to opt in. But this was not a revolutionary, ruling by the court. But in its decision, and this was a decision, an opinion written by Justice Alito, who was a relatively new justice on the court, he expressed misgivings about that settlement that had existed all these years, and a suggestion that he wasn't sure that really made sense under current First Amendment doctrine. So you can be sure that's like a telegram, bring me a case, right? So then we have Harris v. Quinn, which comes up in 2014. This involved a group of home health care workers, and it was a little bit of a strange situation because they kind of existed in between the private sector and the public sector. They really were kind of private contract employees, but the state had passed a law saying that they were, by statute, public sector employees. So again, it was kind of like a weird case that allowed the court to rule pretty narrowly. So all the court said is, we're not saying anything about real public sector workers, but we are going to say these kind of quasi-public sector workers have a more robust First Amendment right than we've given in our previous cases. And they, again, expressed all their misgivings about the way the settlement that had been standing for all these years. And so, again, there's another telegraph. Bring me a case. So they did bring a case that really squarely put the issue that Janus is raising before the court. It was called Friedrichs versus the California Teachers Federation, I believe it was, or association, I can't remember which union it was. But Friedrichs went up to the Supreme Court, and while it was sitting before everyone thought Friedrichs was basically everything I'm saying about Janus now. The only thing that was different was that Justice Scalia, so it was before this court, right? So when I was going around giving this talk back then, I actually thought, Scalia was one of those ones who had come out against the right to work litigants in that 1980s case. So I thought they had a chance on Friedrichs, right? That actually Scalia might again say no. But then while the case was still pending before the court, Justice Scalia died. And then we had a court that was split 4-4, and basically, meant that when the court divides evenly like that, the last decision in the appellate court stays in place. And the last decision in the appellate court had just applied a boot and said, "What are you talking about? Well-settled law. You don't have any claim here," right? So Janus is actually the answer again. So, everyone's gotten the telegraph. They've been trying to get these cases moving up through the courts to come to the Supreme Court, and Janus is really just the most recent one to get there. So the question was, in my opinion, why is it that people don't realize that they don't have any kinds of protections in the private sector workplace? I mean, that is a really hard question. Some people argue that the reason is that, it's in the interest of most employers to make us feel secure and to treat us decently because they don't want us, they want good morale in their workforce, et cetera, et cetera. So some scholars say this is exactly why you don't need laws to come in and give these kinds of protections that we were just talking about earlier, because most employers have their own interests to just treat workers well anyway, and having the law would just muck everything up and create expenses and et cetera. So one argument is people think they have these rights because they're mostly treated as if they have these rights. And so that's, they just come to conclude that there's some legal force behind it. I don't know if that's true, but it is, I will say, there have been a number of empirical studies that do show that people dramatically overestimate the legal protections they have in the workplace. They think if they're in the private sector that they have constitutional rights. You will hear people all the time say, what, that violates my First Amendment rights to free speech, But even some of the things that, what exactly unemployment insurance will cover, or other kinds of, not constitutional laws, but other kinds of laws, people generally vastly overestimate the protections they have in the workplace. And I feel like if I accomplish nothing else out of my book, if it helps to disabuse people of the idea that they have these protections, I feel like that will have been, an accomplishment in and of itself. So the question is, how much are these worker plaintiffs just, poster people, for show, and how much are they really reflecting a broad sense among workers that they do not want to have to join or support unions? So I can speak with much more authority about the past than the present. But I would say one thing I didn't emphasize it so much here, but I really emphasize in the book is that it would be wrong, particularly in the 50s, 60s, and 70s, to describe these plaintiffs as just poster people. So you got a little sense of that when I said, hundreds of railroad workers signed on to those railroad cases. I can't remember exactly what the count is. I think I had over 500 workers signed on to, in various ways, to the briefs in those cases. Ernest Smith, like I said, he organized 5% of Detroit's teachers to join this lawsuit. So these were not, of course, 5% is just a small percentage, and hundreds of railroad workers on the vast railroads of this country are not, are still a small percentage of the railroad workers. But it's also not fair, I think, to just say these were a few, just a few people who got bought out by the boss or something like that. I think to do that would not be to really grapple with what animated their support for these lawsuits. Interestingly, though, a lot of these people who signed on to the lawsuits were union members. They were just not members of the union that was going to get that union security agreement. So part of the mass opposition to union security agreements and these turn to right to work claims came from people who favored unions. They really weren't just, saying a line when they said, I'm not anti-union, I'm just, for the right to work, right? They really were. On the railroads, part of what ended up, what led to those railroad cases was that the railroads had these traditional old craft-style unions. They were kind of very, very powerful, very old school. And there was a group of workers who were trying to organize more of a new industrial style, kind of CIO style union on the railroads, and the brotherhoods were crushing them. But they were getting somewhere in the early 50s. But once these union security agreements came along, there was no way they were going to be the union that got the union security agreement, and the brotherhoods would just clear the field of them. And so Hoosier, that guy, Lafayette Hoosier, right? Remember, he was one of the people who was trying to organize this new industrial union on the railroads, and ended up, instead of, when the union couldn't go, he became a right-to-work litigant and a leader in that movement. So, again, for labor, the point is, I think both, even workers who oppose right-to-work are not necessarily opposed to unions. And a reminder that there have been some costs. They've lost some people in pursuing things like exclusive representation and union security agreements and things like that.